Welcome to the ACIT Podcast, the official podcast of the Association for Critical and Interdisciplinary Thinking. We have a somewhat more relaxed intro now, but we are still hoping to provide you with thought-provoking and stimulating conversations with researchers from all kinds of backgrounds and from all over the world. As always, you can find out more about us at www.acit-science.com. And now, without any further ado, let's jump right in. Awesome. Hello, everyone. I'm here with Driek Deferme. Thanks a lot for joining us on the ACIT podcast.
Very glad to be here. Thank you for having me.
Just going to start with a short introduction about you and your background. You studied law at KU Leuven and get your master's degree researching open source software and patent law. And now you're also doing your PhD in Leuven with a focus on time limitations in civil law. And you recently spoke about that topic at an ACIT Belgium event. And I found the topic really super interesting. So it's great that you now also took the time to join us on the podcast to discuss it again, perhaps even in more depth. And before we get into any of the details of your research, just as a very broad meta question, why did you decide to go into law? Why are you a lawyer, a law student, and what fascinates you about the topic?
A lot of questions in one. I will start with like the latest question because I guess everything flows out of that one. I have to be honest, I really didn't start studying law with like a vision in mind. It was more like, okay, I need to pick something to study. So what did I do? I picked law because it's very broad, and I also had an interest in philosophy and history, and a law degree like filled all of the gaps, especially in the first years. It's a very broad spectrum. And then the more I got into it, I started connecting with what law wanted to do, and that's basically problem solving of human problems. And it always interested me in some way to kind of try to solve a riddle that two people have, and they try to find like the best outcome. And then how can law try to help in that topic. And that's also kind of the reason why I went into research about law. Because after my master degree, I did an extra master in notary law. And there you had also some practical experiences that you needed like to follow and help a real life practice. And I saw that you can only really do some problem solving in law if your basis is very clear, meaning your legislative basis, the case law. And if you do not have the clear fundamentals, then trying to solve a problem for people on like a law domain is very difficult. And even trying to explain people when you find a solution, how you get the solution, if there's not really like a fundamental principle where it is based upon, people will be, okay, I get the solution, but why? And the whole question about why do we have certain rules and why do certain values of a society get translated in those legislative rules really got me into kind of the research part. And that's also why I started my PhD. And also that's to do a lot with my current professor who guides me in the whole process. Because he really, I owe a lot of him because he showed me interest, because I never thought about doing a PhD initially because I thought, I'm not smart enough. You have that vision that PhD students are like top of the line, very smart people. And I was always, I can't reach that. It's way too hard. But he still like kind of pushed me. And I'm very happy to be in a position where I'm now. I feel very privileged. It's the most wonderful job if you like doing research.
Yeah.
If you don't like doing research, it can be a horrible job. But that's kind of how I got into law. And the why is, it's a very weird way in a sense to solve human problems.
Yeah.
But interesting.
Yeah. I recently encountered the idea that the law is a pretty new invention, evolutionary speaking. So I don't know, maybe we can move a bit towards this evolutionary psychology perspective on why laws even exist in the first place. And the point, I think it was made by Robert Sapolsky, that we only have laws because a thing like anonymity exists in our societies. Because previously, when we lived in small tribes of 100, 150 people, everyone constantly knew everyone else. And if someone was murdered, it was probably extremely obvious who was the culprit. So now that we move to societies where you kind of need to regulate the interactions between strangers and kind of codify them, that is even like the first place where something like the law is necessary.
Yes, that's completely true. Because yeah, I had a professor who says Roman law doesn't really exist because it's a very complicated situation, but a lot of people really see that as the first origin or hear for the first time about the whole law system. Um, but it goes way back than Roman law. You had around the Middle East, you had a lot of like tablets with basic principles about how one should act. And that, yeah, the kind of development was with the more people you live, indeed, the more unknown everyone becomes, and the more need you have to regulate at some level. But you have a lot of difference in how much will you regulate, which is also kind a little bit of a difference between the US and Europe, where Europe has a tendency to regulate much more than the US has a more laissez-faire approach. But basically, there's always trying to have in some way find a balance between all the different interests that live in a society, which is, you could say, an impossible task. Um, and I would think that the difficulty now is more that in the beginning, law and philosophy were very closely related, and then it developed into the Middle Ages with religion and law. But you still saw in law a lot of the idea about how does God play a role in this, and then more based on the moral principles. Whereas you look at law now, for example, in my research, time limitations, the question is very much what is our moral basis? Why do we have certain legislation? And I think that's also kind of a bit the frustration that we have today, is that you have a lot of legislation and it's hard to see or find like the societal moral standpoint or philosophy about how the rule evolved. Because a lot of basic concepts, let's take time limitations, which is easiest for me to as an example, they already developed in the Middle Ages, so they're like centuries old. And first, there were not a lot of time limits. It was thought, well, if you did some injustice, it needs to be repented, and it's only God who can like deliver the justice. So we don't put any time limits on it, and you can be sued and be brought before court as long as you lived. But then they saw, well, this gives rise to a lot of difficulties in which we can go into later. But then from like more and more the evolution until the civil code in the late 1800s, they decided that we need some kind of system because we don't find it acceptable that someone, for a deed that he committed 50 years ago, can now be claimed damages. You have a lot of difficulty with like something, if you damage, yeah, it's a very stupid example, but a cow was then the problem. And you then 50 years later you say, hey, you know that cow that you stole from me or that you damaged, how are you going to prove it? Do you want a whole court case about something that 50 years ago? Witnesses are dead. Maybe the person who committed the crime, or you want the damages from. You claim it against the family. The family gets the claim, and they're like, please, what are you doing? So I felt like more and more the need about you want some societal peace and an end of conflict. And now in my research, when you look at time limits, we again are swinging the pendulum in the other direction. We're more evolving again towards less and less time limits. But I try to look what is the moral basis for softening and like evolving beyond time limits. So meaning you can claim as long as you want and sue someone before court. But I find it very difficult. And I think a reason is also that you have that philosophy and law are getting more and more split from each other, and a lot of legislation is just taken in the moment. There is a public outcry. Okay, we need to change it without like thinking things through.
Yeah, it seems like in a postmodern world, it's harder to find like one moral philosophy to agree on. And back in the day, as you mentioned, the law and religion was much more closely intertwined. You had like, in the initial stages of morality, you had moralizing gods, and gods kind of represented the law. And then, yeah, also in Christianity, for example, God is really closely associated with the law, and God instigates the Ten Commandments, gives them to Moses, and kind of as this abstract representation of these laws set in stone, as you also mentioned in Codex Hammurabi, for example, that you really have this idea that kind of a divine principle is instilled in stone, and then there's kind of this metaphysical relevance. And nowadays, like, morality is really, or like the law is kind of maybe in a vacuum, because as societies we don't agree on one divine principle anymore.
Yes, indeed. And I'm not saying like we need to go back to the Middle Ages, one divine principle, hooray!
Yeah.
Not at all, but it's really a difficulty which we're confronted more and more. Because I think in my, which I did the research about time limits and I tried to find what's the basis, but the only thing I really could find was it's a balancing of interests. You have two parties and you need to try to find a balance. But of course, a balance of interests depends on your whole societal background. You have societies in which you put more emphasis on the victim, which is an evolution we're going to now. I'm not saying it's bad, but it's kind of whole victimology uprising, more focus on the victims. We need to compensate and give attention and recognize them, on which I all agree. But then it's very difficult about how are you going to translate in legislation, because either it's like, oh, we need to do something for the victims, and the defense are you're just purely forgotten, and just okay, go for the victims, and then is where is your balance. But on the other side, I think it's indeed the problem on what are you going to base your balance. Of course, my research stops a little bit because I have to draw the line somewhere where legal research ends, and societal, like, sociology, psychology, and so on starts. Um, but that's a very interesting idea about how it's more and more faded away, and it has to do, of course, that law needs to be objective. When you had like the one divine principle, times weren't very well. Law was just someone who had the power who said, "Okay, we're going to do things this way and nothing else." Whereas now you have, it's not perfect, of course, but you have more leeway for minorities in some way to get recognition and to fight the power. However, of course, everyone would say today that that's not the case at all.
Yeah. Maybe as you already mentioned it a couple of times, can you quickly define what time limitations are? So
Yeah,
everyone's
of course,
going
of course.
yeah.
So it's very simply put, the legislator who states or says against parties, after a certain amount of time, you can't bring your case to a court anymore. So a judge is not going to make any decision or convict someone. Now, why is that important? Because the state has in our modern society the monopoly on violence, meaning you can't force your neighbor to do something with violence or any way. The only person who can do it is the state, and you need a court order for that. So you need a judge. But the state says, well, after a certain amount of time, you're not allowed to do that anymore. Now, a lot of reasons for that. First, when you put a time limit on something, it's kind of a deadline. You want the other person to act quickly. Um, and also, you have a lot of problems with proof. For example, you're in a car accident. And in car accident, it's not always clear who was at fault. Was there a fault? Was it a real accident? Were both drivers at fault? Or was one person really at fault? And you have a lot of situations where you have one person who has a lot of damages and needs to go to the hospital, whereas the other person has no real problem, but is still in shock. So the person who has a problem goes to the hospital and they say, okay, your leg is broken, but at the end everything seems fine. It's just like a regular injury. And just so physiotherapy, rest a little, and all is well. And you do that, and you say against the other person, well, it's an accident, it happens, I'm not going to claim any damages, we're not going to make a court case out of it, I just want to focus now, I want to assess, take everything in, take my time. The other person, full of shame, guilt, who's like, sorry, I didn't intend to, is also a little bit relieved, okay. But then, of course, complications arise. Everything goes well for a couple of years, but then your leg starts to ache a little bit more. You need more physiotherapy. You need to see a doctor. You need a next operation. And everyone agrees, well, it all has to do with the car accident. Yeah. And that's not only to do with our broken legs. You have a lot of diseases who just settle in after a couple of years. And then after 6 years, for example, you decide, I need to claim those damages. My hospital bills are way too high. All the physiotherapy, for example, my insurance, social security, they don't cover everything anymore. So you go to the other party. And they're surprised. They're like, what, 6 years later? You come about a car accident? Huh? So they deny everything. They say I was not at fault. And then you decide as a victim, okay, court case. I want my money. It's a lot on the line. Okay. And then the whole problem starts. Everyone sees from the victim's perspective, well, why shouldn't he be able to go to court? It's very simple. There are damages, he has serious injuries, he needs help. But most of the time, the whole perspective from the defendant in this case is a little bit forgotten. Imagine that you had the car accident, which was also not a pleasant experience. You had the luck that nothing worse came out. But at the moment of the accident, it was not clear who was at fault or was there even a fault. Now, try to prove that 6 years later. How? You as a defendant, you thought everything was over. The other person never claimed anything, didn't say a word. Whereas the victim probably has all his medical expenses, all his bills, all his communication with the hospital and so on. So he has a bunch of evidence, whereas the other party has nothing. So you have that problem. How is he going to prove that he is innocent? Which, well, may be. So the law then says, well, this whole problem of proof and the whole trial is not a pleasant experience. We don't want that anymore. So if you as a victim, for example, in Belgium, it's the case, after 5 years, you knew who caused the accident. You knew that the injury was also caused by the accident. Well, if you wait more than 5 years, I'm sorry. We can't help you anymore. You had to act quicker. Of course, there are nuances and exceptions and so on, but the very basic idea is we end this here. The idea is also you have the other party. Having a court case, taking a lawyer is a sudden financial burden which you didn't take into account. Suddenly it's there. Also, the whole problem of you have a sudden conflict which takes years to resolve, and we as a society, that's the idea, want to end conflicts at a certain point, because it's also kind of a philosophical idea that the more time that passes, the less the injustice is felt by people. Yeah. And the idea is also that you need, with children, for example, if you want to teach them something like the Pavlov reflex, you want it to have quickly. Not that they did something wrong and then after 4 weeks you say, remember that one thing. Well, now you don't. You get punished between, paraphrased as such. So that's also the whole idea about the law. You can't wait 20, 30 years and then say, I don't like that person anymore, I'm going to sue him. And that's kind of what time limitations do. They make an end to a conflict. But yeah.
Okay, so now you gave a relatively specific case of time limitation taking action in the case of the bike accident. And time limitations pretty much take place in every part of the law, in both in criminal law and in civil law. Can you maybe explain like what different kind of situations can occur in this way? Maybe I think the most obvious ones we as humans think of is like murder or other kinds of heavily penalized acts in the societies. I think one very interesting thing we can talk about is sexual assault or violence against minors, and this whole controversy around that took place recently. Maybe we can start with a like,
Yeah,
what
of course.
can occur.
So you have indeed, like, time limitations are in every area. So my main research is about private law, and the reason I had to specify it is because there's so much about it. But also, for example, indeed in criminal law, but also in tax law, it is like very frequently. For example, in 2020 and 2021, there were some convictions by the European Court of Human Rights about legislators who changed time limitation periods for tax, meaning they wanted to claim more taxes from the individual after the initial period. And there, the European Court of Human Rights had to step in and say, no, this goes too far. You can't just like say we're going to change the legislation so that you extend time limitations in your favor so you can ask more taxes to the normal person. So it's much more common in everyday life than people often think. The most of the time why you don't see time limitations is because the state or corporations know when certain claims are when they're too late, and then they don't even try to sue you because they know all the effort and then the chance of the whole procedure and so on. We don't want to make all those costs, so we just let the claim fall. But the dynamic between criminal law and private law is also very interesting because most of the time, let's take indeed the example you mentioned of the sexual abuse cases. People try to file a complaint with the police. So the public ministry, so the prosecutor for the state and the lawyer for the state, goes to court and tries to have like at least a fine, but in the ideal situation, a prison sentence and so on. And then you could say also, okay, it's a pure criminal point of view, the time limitations. Well, no. Because if that fails, for some reason, maybe he's acquitted, there was not enough proof, or there was a time limitation, it was a board, people often try to go to the civil side. So they say, okay, if we don't get any criminal conviction, we'll try our best to get some damages. And an example where that's the case is the United Kingdom. You have a lot of cases about sexual abuse against minors that happened 20, 30 years ago. And then suddenly, I read recently an example of someone abused until his 17 years. He became 18. Everything went well. He built a business, very successful person. And then 20 years later, he ran very accidentally against the person who abused him when he was 17 into the street. And suddenly everything came back. And he was like, okay, I have to do something with this now. Also, he's matured a lot. And after 20 years, you have some time to think everything over. So he decided to file a claim because the problem was the criminal time limitations once was already expired and so on. So he tried to have the whole procedure in civil law, of course. And in civil law, not in every system, but in some systems, the time limitations are much more flexible. You have much more leeway. And the relationship between criminal law and civil law is very much that civil law is a backup if the criminal part fails. Is it an ideal backup? I don't know. It's not always the case because if you look, for example, in Belgium, you have recent legislation where they abolished the time limitations again, where there is abuse of a minor. So there you do have time limitations in civil law. So it could be that you can't get any damages, but that the wrongdoer can still be put in prison. But that's why countries choose a certain system is unclear. It's kind of a discretionary thing, I guess.
Yeah, I think the one important point behind time limitations, as you mentioned, is that it also takes some like pragmatic organizational burden from the law system, because you can't reopen any cases after a certain amount of time, and considering they lie pretty far into the past, then they usually involve a lot of conflict and problems with getting evidence, for example. You also mentioned during your talk these examples of like revolutions in the way we think about evidence, also potentially affecting the way we think about time limitations, especially in criminal law. Like, how does it fit together?
Yeah, that's true. So the whole idea is that back in the day, like let's take 2 centuries ago, we didn't have any DNA, we didn't have audio and visual evidence, we didn't have computers where you can like save all your documents, we didn't have the cloud. So most of the time, evidence was you call your friends, your farmers, or the if you had a high authority like the headmaster of the school who witnessed. And was a lot of witnesses from A, a lot of witnesses from B, and then the judge tries to make up which story is the most believable in some way, and we go from there. But then they figured out, well, after 20 years, most of the people are probably very old, even dead. Um, so yeah, what are we going to? We can't have a trial where we have one or two witnesses, and it's about a fact 20 years ago, and everyone back then there was no legal research about it. But memory isn't the most reliable about events 20 years ago. So that was the whole idea. We need time limitations because this doesn't work anymore. How can a judge even make like a sensible decision? So they state, okay, judge, you do not need to like decide about this difficult case, and also indeed the whole burden of lawyers and then the expense of trying to find witnesses, bringing them for court takes a long while, process takes a lot, costs a lot of money, and also if you as an individual need to pay a lawyer, that's not something you want. So they say time limitations. But now, of course, since I think the 1990s and onwards, with the whole revolution of DNA, which is very successful and used also very successfully in criminal courts, but also the whole idea that you have documents which you can then save, and also that people know we need to keep documents much better than they did way back, and also much more is written now than there was way back in the time. The whole idea was, well, do we really need those time limitations, or can't we just extend them? But in criminal law, the problem, but then I'm speaking from Belgium law, but I think it's also more general, you can't only rely, for example, on DNA evidence. A judge will never convict someone purely and solely on the basis of DNA. So you still need supplementary evidence. And that is often in the form of witnesses and memories. So statement of the victim and statement of the wrongdoer. Of course, the longer the event is in the past, the more problems you have with memory. I have a colleague and friend, and also a professor at the KU Leuven who do a lot of research about the influence. And there's also a very famous professor in the US. I forgot her name, but she's very famous about research of the influence of memory on the influence of time on memory, and then the relationship to the law. And when you talk, for example, about, for example, the sexual abuse, you talk to your parents, you get suggestive memory, you get false memory. Without even knowing it, you try to fill in gaps with suggestions, depending on the questioning of persons, which is also a very problematic point with police investigations and the wording of the question and suggestion and so on. And then you have two people who have to say two different things, and a judge needs to decide on an event about about something that happened in the past, 20 years ago, with memory. And they could say, but you have the DNA. Yes, but still, that's not enough. Like, you have the DNA, so the whole problem, for example, um, with sexual abuse against minors, also, if there is consent or not, the age difference also matters. But the consent you can't prove with DNA. How are you going to prove consent with DNA? And also, if you have different degrees of murder, if it's premeditated or not, you can't prove with DNA. But that also influences the whole idea of how severe is the punishment. So you still have the whole problem that we had 2 centuries ago about memory and witnesses and remembering. And also, that's more off topic. You have in the US and also in the Netherlands, for examples, reopened cases about people that were innocent, put in jail on the basis of more modern technologies, then reopened and looked at the whole problem and statements and so on, and they saw that there were a lot of problems and evidence that didn't really fit, and then recollections that were not really true if you checked like the physical place where everything happened. So what happened? Indeed, those people were innocent. They were put in jail, innocent, for a number of years. Do you want that as a society or not? Are questions to be asked. But I think there even you could say this is all criminal law, Driek. What has this to do with your research? Well, even in civil law, the whole question about asking damages for sexual abuse has exactly the same problem. You have the DNA takes there a less important role, but still the whole idea of witnesses and the circumstances, medical reports. A hospital doesn't keep reports of everything that happened 20 years ago. Even people wanted to, does not happen at all. It costs a lot of money for hospitals to just keep every record. So even in civil law, if you say I was abused, I went to the hospital, everything was put up. If you then 20 years later want to ask the documentation, often it's not there. And then a judge needs to make a decision. And then you would need to know, you have the whole discussion. When do you, if you have time limits, do you put it in front of the whole discussion? So that's the first point on the agenda. We're not going to talk about anything else before we know that you're on time. But still, even to get to that phase of the trial, you still have a long way. That has already been gone through a lot of like talks with lawyers, also negotiations happens a lot. You don't see it in court cases, but and the whole process is not the most pleasant experience. So time limitations can, it's the idea that time limitations can take the burden of courts and also a little bit of people. It's unpleasant to hear that your claim is inadmissible because you were too late. Nobody wants to hear that. But I always pose then the other question. Well, for example, if it's in criminal law, do you want to hear the question? No, not the question, the answer that the judge, after the whole trial, says, well, I don't have enough proof. There is kind of doubt in my mind, but the criminal law, you need beyond a reasonable doubt. There's not enough evidence, and that means I need to acquit the wrongdoer, meaning saying he is innocent. And then my question is, do you want to hear a claim is inadmissible versus the wrongdoer is innocent? It's an open question.
I guess from a different perspective, when it comes to sexual abuse of minors especially, there's such a huge reputational penalty in our society to even be involved in a trial regarding that can just bring up a lot of conflict and problems for people. Like even if it turns out they are like freed from all charges or spoken innocent, that can potentially also like cause a lot of stress and reputational harm. So I guess maybe that's kind of the other perspective on the thing, that not only acquitting the wrongdoer is bad for the victim, but even opening up the case can potentially be really bad for someone. And even if that turns out to be no proof at all, or even if that person wasn't even doing anything wrong.
Yes, that's completely true. And that's the whole idea why the law system in criminal law has the basis of presumption of innocence. Nobody is deemed guilty unless the judge says so. But indeed, if you put like the defendant through the whole trial, and you have cases where the defendant is indeed innocent. So everybody always thinks, well, there is a trial, that must mean that the other person is guilty. No, not at all. There's kind of a suspicion, but that's just it. It's the public prosecutor who uses his intuition, which is very good most of the time, but humans make errors. We make mistakes. But putting someone through the whole trial is a very big thing. It's really not the most pleasant experience. And that's nothing to say that victims don't deserve a place in the law system, not at all. But it's, I think, an element that sometimes is forgotten, about the shoes of the other person, of the defendant. And criminal law is a very severe thing to have a criminal case above your head, but don't underestimate, for example, in civil law, if someone claims 50,000 euros, for a lot of people, that's a huge financial burden. It will ruin your life if you suddenly have to pay 50,000 euros. I don't know a lot of people who just have that sitting on their bank account, like, here, no problem, I'll pay it. And not taking into account the costs, where the judge then says you also have to pay the costs of the whole trial and maybe even of the lawyer of the other person, not disregarding your own lawyer. Well, then you're far from home. So it's a very important thing that needs to be thought about, like putting you to a whole trial, especially if you're innocent, especially after 20, 30 years.
Yeah. I guess one important other aspect on time limitations is just how we as a society think about guilt, like not from a pragmatic perspective, but more from this philosophical, what constitutes you as a person, and are you allowed to change over a period in your life where at a certain point you are not really accountable for the wrongdoings of a completely different period of your life. So how does it factor in?
Yes, that's the whole idea about how do we translate justice, or the feeling of injustice, into legal terms and ways. And that is indeed in society now, in court cases, like in criminal law, you see it in the legislator in Belgium. In civil law, you see it in the court cases, where more and more, indeed, the feeling is that it's more unjust to have no trial because of time limitations than to have a trial. Meaning, we put more emphasis on the victim, the person who wants to claim damages, and we indeed have the feeling now that time limitations are less and less at place. And as a legal scholar, it's very difficult to have an opinion about it because you're deemed to be objective and just like say this is the tendency, and here is a tendency. Make up your own mind. I'm just giving it and saying, if you want to go that route, which I'm also doing in my research, okay, you want to put the focus on victims. How can you translate this the best in legislation and in uses in court cases? Meaning, you want coherent and consistent legislation, which is also always the basis. You want like the certainty, that the law is predictable, and not that you have the law who says A and then the judge who says B, C, and D, which happens, and which is happening right now because the injustice is felt. And it's the whole balance between the judge dancing between the boundaries of law to kind of try to correct the injustice that the legislator created, which is then also from a democratic point of view the question about, can a judge do this? Of course, if it's in the boundaries of law, yes, but was that the intention? And that's the whole question, that the debate is sometimes more put into court than it is before a parliament, or that a parliament makes a decision just based on, which happened in Belgium, for example, like the whole abolishment of time limitations in criminal law for the abuse against minors. Was a decision that was taken like this because a couple of years earlier there was very extensive reports about why we should not abolish them, with a lot of research, investigation, and so on. And then a couple of years later they say, abolish them. And why? I try to understand why. There's no clear reason given. I ask questions about why would you suddenly change. I get that society changes, but so suddenly, and you see that, I guess in time limitations, you see that in a lot of domains, also with tax law, for example, that the state tries to prolong more and more how long they can try to claim taxes from citizens. And that's like everyone, oh, but we need time limitations in tax law. I don't want to pay taxes 20 years that I forgot to pay 20 years ago.
Yeah.
And then it's like, okay. So time limitations is very much always what kind of interest do you want to defend?
Yeah. About that Belgian case of abolishing these time limitations for the abuse of minors. It's a very interesting situation because, like, as you mentioned, it was like heavily debated, and then they came to exactly the opposite conclusion of what they then turned out to do like a couple of years later. Now they were abolished. Like, could you identify any like one reason? Was it more? Do you think it was like a political move of also in the context of there being a lot of abuse cases from the past being unearthed in the Catholic Church and in a lot of kind of institutions, and also in the wake of the Me Too movement, there being a lot more awareness of sexual abuse having potentially taken place in a time where it wasn't as like we as a society didn't really deal with it too well, but just ignored it basically.
So for the first question about like why the Belgian legislator suddenly decided to turn 180 degrees, like the first one, which they try to also frame as a more important one, is like the whole change of evidence gathering, and like I mentioned, the uprising of DNA, video, and audio. But I don't really see that as a valid reason, like I already mentioned. That was also kind of based on the Netherlands, because in the Netherlands they also changed their legislation and they also abolished it, also for the reasons of proof. And then the second reason was also that, like you mentioned, society now does not really feel that after a certain amount of time, a person should be free of any guilt. So the need for punishment now, also in the future, is much more felt than it was 50 years ago, for example. And indeed, the question if it has to do with the searching cases, I don't really know, because the moment they decided initially not to abolish was in the light of the sexual abuse by the Catholic Church. So it was the whole idea, no, not the idea, the whole movement then that gave rise to the research, and they stated no abolishment. Now, reference to the Me Too movement I did not find in parliamentary documents in Belgium. So yeah, I tried to like look for a reason, but I couldn't really find one that was convincing, in my opinion, of course. And I guess it's just a sudden course. Probably there will be like a valid reason why they did it, but I can't figure it out from the documents.
Yeah, that's weird and interesting.
It's a tactic, you know.
Yeah.
You just publish some documents and you say some things. Like the opposition, who had questions about the abolishments, they were much more clear in their critique than the reasoning was of the majority who decided to abolish. So the critique that I already also gave was also found back in the legislative documents, but there was no really answer why. Also, someone asked why the sudden change. Couldn't really find one.
Yeah. Yeah, it seems, as you also mentioned in your talk, that the things that don't have any time limitations kind of reflect what we as a society think is the worst thing someone can possibly do. And you actually have a time limitation still on murder, but you don't have it on sexual abuse of minors. And you also don't have it for war crimes or something like that. And like,
Yes, that's true. So originally in Belgium, the only crimes that had no time limitations, were genocides, crime against humanities, and that was also from international treaties, which had to do then with World War II. So meaning like on the scale of what happened in World War II, which then also was the case in France. And the reason why the French legislator ultimately decided not to abolish for sexual abuse against minors, because they stated, however severe the crime may be, it's still not on the same level as, yeah, crimes against humanity or genocide, which indeed is the whole idea. What we as a society, you have like punishment, which, yeah, is a reflection of how severe a crime is. But if there's a time limitation or not is also an indication, which then, I'm not saying it's wrong, of course, about sexual abuse against minors. It's horrific. It's like, yeah, I can't really imagine many things that are worse. Um, but yeah, it's something to reflect on about why indeed for murder that's premeditated, you still have a time limitation. Why not? Yeah, you also have the whole idea about the constitutional court. How thin is the line with saying it's discriminatory to have it for murder but not for sexual abuse? Of course, there's also always like that's a classic argument you can say as a legal researcher. It's the discretionary power of the legislator, and in some way it is. It's what the democratic society deems important, where law stops and politics start. It's a very difficult, uh, line, and you see this in every area, because criminal law always speaks to people's imagination. But to link it back to civil law, you have the whole, for example, idea that in Belgium, or in other countries, that damages you want to claim from a personal injury, the time limitations are much more flexible than damages from a car that's broken. And so material damage is deemed less important than personal injury, um, which is also very interesting. And the same can be said if you have damages from a contract. For example, you make an agreement with someone, they don't fulfill their part of the deal. You have less time to ask for damages than, for example, in a car accident when there was no agreement and the event happened. So it is indeed interesting to look at societal tendencies about what do we deem more unjust. And most of the time, indeed, you look at the punishment or you look at how much damage you can claim. But another way is indeed time limitations, which is in a lot of cases forgotten. It's just like brushed over very quickly without looking at the real basis why we should prolong them or even abolish them.
Yeah, I was, as a German, again reminded of these cases where Nazi concentration camp guards were still now. I think there was a court case last year against someone that was now in his 90s. That was, I think, 18 when he was a camp guard in Auschwitz. And that was really, again, as you mentioned, a place where like the law and politics kind of were intertwined, because like from a law perspective, or like from like avoiding harm for society, it was pretty clear that that 90-year-old man would probably not like commit any crimes that he committed with 18, but just to signify that the Holocaust and everything that happened in the concentration camps was horrible enough to justify that there's really no time limitation for the perpetrators of doing something like that, and that you could never really, after participating in this kind of horrible system, expect peace in your life, so to speak, from any responsibility on that front. That seemed to me to be a very important like signal to send, kind of also for Germany as a nation as a whole to still deal with this past. And actually, it was really interesting to think about the like how people thought about the Holocaust, like from a temporal perspective, that it was mostly ignored and not talked about like for maybe 30, 40 years, and only really started to surface in public discourse in the 90s. And now it has actually increased in intensity. And maybe something that's so horrible needs kind of some time to settle for people to start thinking about it from a like more objective perspective and try to figure out like who's to blame and how can we actually deal with something like that. Yeah. And then in this sense, it makes a lot of sense to not say, yeah, if you like 20 years after a genocide, people can't be taken accountable anymore. Because I think in the initial phases, it was also something during the genocide in Rwanda, where you really have an extremely divided land afterwards, and you need to focus on reconciliation first to a degree. But it's also really difficult to imagine then just saying after a couple of years now, no, nothing is,
Yes,
you're
it's
not to
true.
blame anymore.
And that's also with the sexual abuse. It's also a lot. The argument that's given, yeah, it's very serious, and the victim first needs some recalibration, like to get over the trauma, to be able to face the facts, and like you mentioned with, genocide is like a very extreme example, of course, but sometimes you first need to put everything in order, clean up your room, to say it metaphorically, and then you have the power and the strength to go with a court case, which is also stated with sexual abuse cases. And then indeed, I'm not saying that having time limitations is wrong. That's very respectable as a reason, I think. But my idea is that most of the time, other factors that time has an influence on are just forgotten. Which, like with genocide, proving it is most of the time not difficult. But if it has to do with crimes that have to do with one victim, it, like, for example, having therapy. I'm all for psychological therapy. It's very important, but it's not a good start for a court case, because the amount of court cases that start from psychological guidance that were deemed inadmissible because problems with memory, false memories, suggestive memories is very high. Um, and that's, like, as a society, kind of a thing that gets forgotten. Like, maybe you should put more focus. That my idea is also that with time limitations, it's very popular to just say abolish them. Whereas you don't, my opinion, you don't really like treat the cause of the problem. And the problem is you want to help the victim, to recognize the victim, to acknowledge the victim in any sense, if it's sexual abuse or not. You want the feeling of injustice that a person has. The law system wants to take that away and make you come at peace with the whole situation and have justice. But abolishing time limits does not, in my opinion, in most cases, have any influence on that or change that at all. Um, Not saying that you can't abolish them, but there needs to be a reevaluation why. Like with the example you gave, can be a very legitimate reason. But the danger, of course, is what if you were going to systematically do it for everything?
Yeah.
And like with the Holocaust, it's fair. Yeah, okay, I'm not going into a whole conspiracy. Like, it never happened. Of course, it happened. But there, like, proof is redundant. You're never going to have any problem, I guess, with proof, or with false memory or suggestive memory. But you have a lot of cases where that is really the case.
Yeah. Yeah, there was this big, I think, situation in the US where this new idea of these suppressed memories emerged, like from a kind of psychoanalytic perspective, and then there were like police investigators were also trained, like more specifically, to talk to children and kind of have them admit sexual abuse by like, their kindergarten teachers or something. Then there was this whole wave of like new court cases emerging based on this evidence, like this statements from children, and it was only kind of later realized how easy it is to imprint these kind of false memories into children, and there were a lot of people falsely accused based on these statements. Again, this whole unreliability of memory is, I think, becoming clearer and clearer from a neuroscientific perspective now, and it's like,
Yeah, because for example, you have Henry Otgar, who is someone who published a lot on the whole idea, and you have also, that was her name, Loftus, who's very famous in the US, about the whole idea about like suggestion on memory. And everyone who has any interest, I would recommend to read about how memory works, because that's a lot, like the whole memory wars is still going on. The whole idea, does suppressed memory exist or not? You have some sudden recollection of memory does exist and is possible. I think it was, for example, when you see the crime scene back after 20 years without any suggestion or talking, then suddenly everything can come back. Whereas if you talk with people, it's the line to have a real recollection versus suggestion is more thin. And I think that is also to do with the law sometimes, or politics sometimes, not taking experts into account. Now, I'm not talking about the COVID situation where they take maybe experts too much into account, just but there are a lot of domains where, yeah, I think politics and certainly the law can learn from the whole COVID situation. Like, experts are important, and that sometimes is, yeah, not taken into account. Also, if you have a judge, um, like, judges are wonderful people who need to make a moral decision based on a lot of difficult legal technicalities. They have a very tough job, uh, but they don't really know much about memories and how memory work. It's impossible for judges to know everything. So it's also very difficult. Does a judge know, is there suggestive memory or not? Does he know what it is? Does he know what influences it? And then the whole idea, if you have experts, but because people always say, but a judge can appoint an expert can do a judgment. Well, a judge is not bound by experts' advice. So if a judge wants to decide, then he decides. Which also, not to blame judges at all, led to the surging cases in the US. It was also judges who believed some kind of repressed memory ID, maybe, or had some opinion, and then just acted on it. But we can't expect judges to know everything about the human mind or psychology, and that's like the task of the legislator. But if then the legislator makes such quick decisions about, hey, abolish everything, let the judge solve it, no.
Yeah, that seems a very general problem, how to factor in the new scientific developments also in neuroscience psychology, really how to adjust the laws. I think there probably needs to be a lot of interdisciplinary conversation on that front, because really I mean, I think a lot of our conception of guilt really centers on personal responsibility, and yeah, this whole idea of us being sovereign, free-willed actors that can actually decide what they want to do. And now we have slowly a lot of insights chiseling away at that, from genetics to environments to head trauma, for example. Like this one nice example, or probably terrifying example, of, like, I don't know, half of the inmates on death row in the US had head trauma during their childhood. We can really make a pretty obvious connection. You have like damage to the inhibitory control in the prefrontal cortex, and then you don't have control over your violent instincts, and then you obviously commit a crime, and then is it really your responsibility then? Or like, who is really to blame, in quotation marks? It's like not probably your soul that has turned evil, like from this medieval perspective, but something completely different.
Yes, and then the whole question becomes, yeah, is it up to the legislator to think about these cases? Is it a political thing, or is it up to a judge who is probably overworked, has a lot of cases to do, does not always get the best reputation? Um, that's also, I noticed with the whole time limitation debate, it's more, putting the responsibilities, for example, also in criminal law, at the police and at the public prosecutor, to make like the choice. I'm going to prosecute. Yes, no. Is there proof enough? How reliable are the memories? That's not an easy task. For example, in the Netherlands, the legislator took some responsibility and they created a commission whose function is nothing else but to judge the reliability of memories. That's not binding; it's advisory, but it takes a lot of burden from like the police, public prosecutor, the judge, and so on. Of course, like everything, it costs money. Abolishing a law is very cheap. Uh, so most of the time, I'm not blaming politics, of course, but I can see the attractiveness to why, yeah, time limitations and not getting expert advice, for example, like you mentioned from neuroscientific, if you need to try to translate that in legislation, that takes time and money, I
Hmm.
guess.
Yeah, yeah, it's weird because from the outside, I think people just think about the criminal system or the law system as one homogeneous thing. But obviously, then there's a lot of different actors involved, and they kind of shift the responsibilities to each other. People don't want to pay a lot of money, and then you face this responsibility, and then you just say, the judges can handle it, and they don't really have the capacity to handle it, so no one is doing it.
Yeah, and that's also the whole discussion with criminal law. Where does it begin? Is it the educational system? Is it the parents? Is it the childhood? And most of the time, I guess law systems now, I think they're very good. Maybe even the best they could be than they have ever been. But there's still a lot of room for development, and there should be a lot of development, I guess. But for example, especially, I think no, every area of law is the whole idea about how politics in some way tries to structure society without losing touch with society. Um, and for example, if you talk about time limitations, most people are very clear we don't need them until I start talking to them. I can't convince everyone, but they kind of see the point in why we have them. But it doesn't help if then the legislator just starts abolishing everything. It's like, well, I think if we have some rule, even the most boring procedural rule, most of the time it has a reason why we have it. Like there's been discussion, some legal scholar has thought about it, been discussed. So there is some reason why we have it. To then start abolishing everything, it's I always question this. Should we just throw everything, all the hard work that someone did about this overboard? Maybe, of course, society changes. But I think maybe a little bit too quickly
Hmm.
sometimes.
Yes, it's like this idea of revolutions always just taking the status quo, and everything that pre-exists is horrible, and so you just throw everything under the bus. But then you realize that a lot of the things that were already there served a purpose, and it's really hard to start from scratch. It's maybe like general wisdom to follow in life once you get a bit older.
No, that's completely true. And especially I think for yeah, like the same with research. When I started my research, I did not had the idea because I'm going to make a great system. But now I'm happy if I can make some incremental change to the system. I don't need to revolutionize time limitations at all, because the more I read court cases, the more I see how competent judges are, how good they are in deciding those cases. Also, I know I've been bashing a lot at the legislator. It's kind of my job to bash at the legislator, but in most of the time, some countries they do a very good job. So like props to everyone. And then when I look at everyone and even some great legal scholars and thinkers, then sometimes I think I'm not really that new. I'm just trying to make some incremental change, doing my part in like get some more consistent law, more coherent law. Um, and that's also a thing for the where our law system is based on is incremental change and sometimes maybe incremental abolishment.
Yeah, maybe from a meta perspective, how does your research actually look like? Maybe like from a like what do you do all day, and what is the point? Where does it lead to?
Well, I think for everyone who is not familiar with legal research will think, what are you guys even doing? I have colleagues and friends who do like empirical research, and they think, are you even doing research? So basically, what we do or what I do is you look at legislation. That's always the first step because it's like hierarchical, the highest in the hierarchy. Um, and then you look at how is it filled in. Yeah, and that begins with reading court cases, court cases, court cases, court cases, and you try in some way do kind of an inductive exercise, like to look at what is common through all those cases. Look at with what are judges struggling, because most of the time in cases, for example, the United Kingdom is a pleasure to read. You have judges who openly state with what part of the law they have difficulty. And then they start debating with each other as such. You have opinion of Lord A, then opinion of Lord B, and it's very interesting. And you as a researcher try to like alleviate the task to try to come up with a solution for the judge and the legislator. Now, you can do this in a very concrete case, and that's kind of what a lawyer does. He tries in a case-by-case basis to come up with a legal solution. What my research is to try to come up for a solution that is applicable to as many cases as possible, so that the whole case-by-case decision making can be toned down. So it's kind of a scaling up of everything. And also, what I also try to do is put some counterweight against certain tendencies. Like I mentioned, with time limitations, a tendency to just prolong them and just let the victim go to court. I give some counterweight to say, whoa, 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 take it easy. Use also these interests that you need to take into account. And the only thing how I do it is based on legal scholars, what other people thought about the subject, and court cases, and then also try to look at historically how did the legislation develop, and also how did the court cases develop, and kind of try to predict the future in some sense, as in looking at which cases are going to be problematic, and then try to have some rules or at least guidelines ready to the legislator and judges to use when they are faced with those questions. For example, with the whole idea with the criminal law and the sexual abuse, I wrote an article with Professor Otjaar about trying to give some guidance to judges. What can be used? What type of memories do you have? But then more in a layman, non-psychological research kind of idea. Yeah, I know it's very vague because I don't do any experiments or empirical data or statistics or you can see law as a lot of things of philosophy sometimes.
But it's also seems always to be like close to a pragmatic perspective, because like law is kind of the like this abstraction of law doesn't really exist, but it's the lived reality of the law that actually constitutes it. So if there's no courts and no lawyers and no judges, then the law doesn't really exist. So
Yeah, and my research also wouldn't exist
yeah.
because it's based on my whole central research question is purely based about what I've read in court cases and the problem I distilled, and then tried to find a solution for that. Meaning it's maybe like a leeway. It's indeed pragmatic in a sense. What are you with law if the rules are not applied? So you want to give some guidance so they can be applied. Because you're nothing with a rule that a judge says, I don't understand this rule. What must I do with it? And that's kind of what legal research. I think a lot of colleagues would probably shoot me and say, Dick, this is not what legal research is about. That's like how I try to do my research, and you could in some way argue that looking at court cases is empirical evidence. if you really want to look, yeah, very on the surface of what empirical evidence is. Um, so yeah, that's kind of what I do. You have people, for example, in European law, it's a little bit different. It's also looking a lot about all the different countries, and then most of the time, European law tries to have the most common idea of all the countries, their national legal system, and then come through a kind of a common ground, um, which I also try to do, but then on a more detailed level because I do not do it with like 20 countries, for example. But that's also how you can do in some way legal research is to come to more uniform, understandable rules that are acceptable. That's basically what we always want to do. Uniform rules that are acceptable for society.
Yeah, but then it probably also moves closer to philosophy, I guess. Like the more abstract it gets, the more universal it's trying to be.
Yes, and that's. I try to focus more on that because what I do, they sometimes call fundamental research, as in I try to really go to the core of limitation periods because limitation periods can be very detailed. Like the how many exceptions that you have in different legislation that then make a nuance or another exception, and then if this happened, then you need to take into account this, and so on and so on. Which I also do, but I try, which is more sometimes practical, as really pragmatic because then lawyers can use it. But in fundamental research, you really try to go to the core, and like we discussed, why do we have time limitations? How is it developing in society? Why is it developing in society? And I try to give like a solution for both. So if you want to go that way, how can we try to do it as best as we can? But if you decide not to, how can you try to incorporate it? Of course, I'm not objective. Legal research, everyone can try to say that they're objective, but you have some kind of bias which you like to defend. And it's also true with legal research. It's, yeah, like you said, it's kind of philosophy, but then try to make it more pragmatic. However, the whole idea of morality you try to keep out of the equation. You try.
Yeah, it's probably hard to do. But yeah.
Sometimes it is. I try when I do presentations. I try to do my best to give like both points of view. But most of the time, public can know towards what I'm leaning, and in this case, it's don't be so quick to abolish all time limitations, please. But I'm happy if I can like convince some people that there is some worth in it, and then I'm happy. They don't need to agree with me, and that's also the beauty about law. It's subjective.
Yeah, that can actually be nice. There's some like nice disagreement, and a lot of people like having actually like genuine opinions and standpoints that are valuable.
Yeah, it's like also easy as legal researcher. Yeah, you can disagree with me.
Yeah,
It's not like an objective thing, like it's plainly wrong. That happens, of course. You can be plainly wrong about the law or about historical figures, but it's less common, I think, in legal research than it is in, for example, like the hard sciences.
yeah. If it's wrong, it's wrong. It's like pretty straightforward.
Yes,
Physics.
that's not the case at all with law.
Yeah. Like, maybe looking back at your like first years in research, do you have any like I don't know if we are as far yet, but advice or like insights you gained from what you things you might do differently or how to get started?
Uh, well, I think I always like when you have first year colleagues that come to you. So like, do you have any tips? You also have a lot of colleagues who just say, read a lot, dive into the research, and then start writing. My tip is always just start writing. Like ideas, everything you have, put them on paper. I find that most helpful because first of all, my working memory is not that great. If I read something and I need 2 days later, most of the time I completely forgot I read. So I just started writing. Um, First, so you have some sense of progress. Secondly, after a year, you can look, oh damn, my ideas. What was I thinking? Like, where was I? Which was also nice to see then how your thinking and your view and opinion about certain topics changes the longer you're into your research. Um, so I always say to like colleagues who just start, yeah, if you can, I know it's very difficult, but just start writing something. It can be total nonsense. Does not matter. You have the feeling you did something. Because if there's one thing I'm struggling in with my research is having the feeling I did something at the end of the day. Uh, so you have that kind of feeling sometimes, not always. And also, it's like the most amazing job ever. When I started, I was very like I wasn't really convinced I fit it as a researcher. I was more like, I will see where this goes. If it's nothing, I will just stop. I'm not bound by anything. But the more I got into it, the more I thought the freedom that you have to like do what you want. Like you find that interesting, you go for it. If it has something to do with your research, and even then, no, I also have like a. My professor is also very right. Just do what you want. At the end of the day, I will see progress, and that's all that counts. How that progress manifests itself doesn't matter, which is also, I think, very lucky to be in that position because not everyone has that freedom. Um, but yeah, like I don't know, yeah, it's like the most amazing job. But I also found out that it's the most horrible one of the not most horrible, of course not, but it's not a nice job if you don't like doing research. Then
Yeah.
I see a lot of people who are just like, no, this is awful. Driek, how can you say it's the most wonderful job?
Yeah, there's definitely bad places to end up in. There's also this meme page I follow with like PhD memes. It's pretty much like constant existential crisis, like paper submission process and everything. Yeah.
Yeah, indeed. And then reading like peer review, and then have the peer review 4 months later, and then god damn it, now I have to work myself into the whole thing again because I forgot most of it.
Mm.
Yeah, I know like the whole long term thing. I don't have kind of problems with knowing I need to have my project finished in 4 years, for example. No, I have like 2 years left, something like that. Maybe to give some context, like I had initially 6 years, but then I got a external fellowship that then shortened my duration to 5 years in total. So I have like 5 years to do my whole research and also do some teaching. Um, so I'm like more than halfway there, and I see progress now. Now I start to see like results still, but it's like a beautiful job if you like just thinking. But indeed, sometimes you need to stop the thinking and just like write. And also, I try to make it a 9 to 6 job, as in try to work. But I also figured out after like 2 years, it's not really a job. You can't sometimes force yourself to do it. You have like moments, for example, that I'm doing 2 hours nothing. And I want to do something, but I'm just like staring at my screen. And then suddenly, like 11 o'clock in bed, I'm like, ah, damn, that's a good idea. I should go.
Mm.
I should go. And I start taking like half an hour in bed about the whole idea. And like, seriously, it's like, yeah, it's not like a regular job sometimes.
Yeah, I think it shouldn't be. And I also think research is really very nonlinear in its outcomes. Like if it's just an insight or an idea, sometimes going for a walk is more beneficial than just grinding in front of your laptop again.
Yeah.
But I still think like kind of trying to limit, like kind of having time limitations when it comes to your workday, like 9 to 5 or 9 to 6, or how much you wanna work. I think that can be helpful for like keeping mental health going.
Yeah,
And
it's sometimes I just like do to have a reference point. Um, And sometimes like I quit earlier if I'm really not feeling it, and then when I'm in the drive, or sometimes I just pick it back up after dinner. Then I'm like, okay, got it.
Mm.
I'm just at it. Um, because like you said, it's not really a linear job, which is also I think the beauty. But it requires also a lot of discipline. Sometimes I'm putting more effort and energy into doing research than actually doing the research. It's very strange if you have to explain people, but that's very strange feeling. It's not that I'm not interested. I really want to do something, but like the energy to write something, if your brain is not up to it, yeah, can be exhausting.
Yeah, there's this joke about procrastination that you can't do something if you haven't wasted like 4 hours before wanting to do it and not being able to do it. It's just impossible to start right away. So
Yeah, yeah, like for yeah, I do not know if they're like people who want to pursue PhD. But if you're into research, I would like definitely try it. Uh, it's
yeah,
it's amazing, but be prepared. It's nothing what you think it will be. Every
yeah.
colleague I talk to, it's like every expectation they had of what research was going to be failed completely.
Yeah, it's hard to have expectations, but I also think like every PhD is different. It's like really I've talked to a couple here on this podcast as well, and it's like every time I ask like what does your research look like, what have you learned, it's a completely different answer every time. I also think that's very it's kind of cool. It really depends on your supervisor, on your field, on the methodology. Just extremely
Yeah,
varied.
in law, lack of methodology sometimes.
Yeah, so that's when you want to find something new, I guess.
Yeah, I'm just laughing with it. There is some methodology in law.
Yeah,
Not
honestly.
because you have colleagues of mine who put big emphasis on it. But I have to admit, I'm more like the freestyle. I have a problem. I will try to find a solution. Yeah. Everyone needs to write like a research proposal with a whole methodology, and I did everything of that, but then I threw it out the window and I just tried to solve the problem. Um, and I think that's like the most fun about research. It's a huge problem. It's a riddle, and you try to take a crack at the riddle the best of your capabilities, and someone pays you to do it for like 4 or 5 years. It's wonderful.
I guess that's actually the thing that unites all the PhDs in all the fields. It's like really, it's kind of a riddle and you get paid to solve it. And if you are that kind of person, getting paid to solve a riddle is amazing. If you don't like it, then it's just going to crush you slowly.
Yes, that's indeed, it gets the upper hand. Still gets the upper hand of me. I think the only day I will get the upper hand is at my defense. Um, but it's a wonderful thing. I've learned so much about myself. It's very cliche to say that. Um, but also like the wonderful people I've come into contact just because of my research. Like I never imagined it. People always say doing research is very lonely. I still have to find sometimes loneliness. I'm like, oh god damn it, I just want to work. Just leave me alone. I need time to
Mm.
like process this and think about it. Yeah, I do not find it such a lonely job at all.
Yeah, no, there's definitely a lot of space for interaction. It's probably also that you learn a lot of ideas best by talking about them. I think that's kind of, as you mentioned already, starting to write early. I would also recommend starting to talk about ideas as early as possible, like with colleagues, but also trying to make presentations, try to explain it to your friends, and these kind of things really helps you shape out the ideas as well.
Yes, it's true. Like, and also the exercise. Yeah, talk to explain it to your mom or dad.
Mm.
Like, it's yeah. Like I love cliches. Everyone says, "Oh, so cliche," but like I always think they're cliche for something. I mean, if it wasn't, there was some truth in it, then it wouldn't be so common knowledge. Yeah, common knowledge, or common
Yeah,
ground. Like And that's so true. Like you mentioned, like just doing presentations, I've learned a lot. And sometimes the learning is not so much about the specific topic of my research, but about how to do research, about the interesting ideas that other people have, about which you never thought about because of your tunnel vision. Most of the time, it's always like I'm in tunnel vision and I do like a presentation. It's like, okay, now I need to broaden up again because I'm losing some very essential things out of context or something. And it's such a fresh of breath air to do.
Yeah, it's very true. Maybe as a last question, do you have any favorite books that really shaped you or that you can recommend?
Oh, favorite books. That's
Probably a very difficult question, so no
you mean
pressure.
like not boring law books, I hope.
Yeah, I mean, you can say like the financial law of the European Union or something.
Oh yeah, that's always been my every night. No, books. Oh, I'm a big fan of I think the German writer Hermann Hesse.
Yeah,
He's one of my all-time favorite writers. Um, then yeah, some like I'm very traditional, like Dostoevsky from the Russians. Goethe, also German. I love German writers. I love Russian writers. I'm not so much into like the modern um, kind of literature, more like an old school kind of guy, I think. Also the French Sartre, Camus. Yeah, you notice the more philosophical theme.
yeah, yeah, yeah. That's true.
So yeah, and then I guess a book that I always, but it's not really a book, always come back to. Like I'm not really a fan, but because everyone is a fan almost today of Stoicism, you have like Meditations of Marcus Aurelius. Um, it's like it's not really a book, but sometimes just like picking it up, reading some excerpts, like really to have like get to like refocusing, rebalance, take some time to just like okay, put everything back into perspective. Taught me also a lot, and that's maybe the negative thing about doing PhD research is I used to read a lot, and now I don't because my whole job is reading and writing the whole day.
Yeah,
So the amount that's like the sad part that I still read is very small. But if someone does not know Hermann Hesse, please read him. He's a genius. Yeah, it's just
what's
I
your
can't
favorite
tip that.
book by him?
Peter Kamenzind.
Ah,
Kamenzind.
that's like not the most obvious pick. Actually, last podcast Ben spoke about Siddhartha and Steppenwolf, but Peter Kamenzind is also
Yeah,
yeah,
it was like I remember why it's more like I think sentimental. It's like a wonderful book, but it's
yeah,
my teacher of Dutch in my fifth year. I was 16, I think. I wasn't really a big reader, but he like forced us to read some real literature of like the 20th century. And he had like a list with 200 books, unbelievably long. Um, and I was like, okay, I have to read something. I just like picked some at random. And from the first page of that book, I fell in love with literature. And I think like on that list, most of the books I read because of him. I think he's also the reason why I had my interest in like critical thinking. Um, so yeah, if anyone, it's not a thick book at all. It's not a
yeah,
Dostoevsky. It's
yeah,
very
yeah.
small. I think it's also much smaller than Siddhartha or Narcissus and Goldmund and so on.
Mm.
So yeah, it's
Yeah. I actually still remember the day I read it. It was
it's
like 10 years
magical.
10 years ago. It's pretty magical. But all of Hess stuff is I think I've read all of his books at one point, and he's definitely like a huge influence as well.
Yeah, and he didn't like wrote that much. I think if all his works together, it's not like
It's like one Dostoevsky book.
Yeah, I think maybe a little bit more, but like
Yeah.
in the big picture, and still there's so much in it. But can I
Mm.
ask your favorite book? Because now I'm curious.
Yeah, it's a difficult question. Yeah, I think historically speaking, from my autobiography, there like Hesse books are also just had a huge influence on me. Siddhartha just brought me closer to Buddhist thinking philosophy, and then I like looked into that a lot more. From a literature perspective, I really enjoyed the Silmarillion by Tolkien, kind of the backstory of Lord of the Rings, which actually starts literally with the creation of the universe. It's like kind of a creation myth that sets like the whole story and is kind of in this epic tone, which really inspired me also more in my teenage years. Then I really like that Magic Mountain by Thomas Mann, which is also like the Zauberberg, which is like one of the cornerstones of this. Yeah.
I really had to force myself through that one. I get the book, but at that moment I was 17 or something. I really had to push myself through the
Yeah.
book. It's at hindsight, it's a great book, but I do not know if I will read it a second time.
Yeah. I actually started reading it the second time, which was interesting. But I think I also had this magical teenage years reading experience where I just had 2 weeks where I didn't have anything else to do. I think that's also what you mentioned, that with a PhD and everything going on, it's really hard to re-invoke that sense of magic when reading something. I can only get that like when I'm on vacation.
Yeah. Now, it sounds very strange. I sometimes have it when I read court cases. If
Yeah.
it's a well-written court case, it's some it's not a beautiful story. It's like a story and the struggle of two people to find some justice. And if it's well written, I still have that moment, but that's because I get paid, maybe, and not because of
Yeah.
the magical free time and the
Yeah.
message. But yeah, like that's the downside, I think, to doing my PhD. If I had to choose
Mm.
one, like my literature list, I have still so much like standing in my bookcase I haven't touched. Um,
Mm.
just because like I'm too tired after reading so much.
Yeah.
Excuse me.
No worries. Yeah. But I think there's always a place for some literature. I think it's just sometimes it's hard to build up that habit again, but sometimes it also
Yeah,
works.
that's true. I think like it will come back. I think at some point.
Mm. When you're retired, there's a lot of time for.
Let's hope not that late. Because I still have much to read, and I guess until I'm retired, if retired at all, there will be so much published, and if I have to take into account all that, going to be quite a
It's going to be tough.
challenge.
Yeah. But hopefully we will live for a long time. Maybe we can just upload it straight into our brain with some interfaces.
Yeah, I would like. I can't even imagine. I can't even imagine.
Yeah, let's see. So I guess thanks a lot for joining us on the ACIT podcast. And
Thanks a lot for having
great
me. It was
pleasure.
very interesting. I hope I said some interesting stuff.